let's change tack by looking at the Nnamdi Kanu saga. He didn't hold back in court yesterday, calling the judge out for not knowing the law and perverting justice by, ignoring constitutional basics, as the Federal High Court in Abuja fixed November the 20th to deliver judgment in his terrorism trial. Help us understand or help us make sense of this whole thing. Was this rant justifiable in any way?
No, I don't think so. And I don't think I've seen where an accused person standing trial openly showed his anger in the way Nnamdi Kanu has done. I can understand that he's frustrated because at some point he wanted a political resolution of his matter. His lawyer announced in open court that they were open to resolving the matter out of court, but there was no traction on that. I wouldn't know why. All that Awumolo, the prosecuting counsel, said was that it was not in his place to determine whether the charges should be withdrawn in favor of an out-of-court settlement. Kanu said previously that he would restore peace to the Southeast once he's released, and that nobody in the Southeast can disobey him. None of the boys in the Southeast can disobey him. So, but I've always felt that, look, if the issue will be looked at, if the issue will be resolved politically or through dialogue, then Kanu should be ready to make some concessions. I don't know whether he agreed to some conditions. Without agreeing to some conditions, I do not see how government will simply allow him to go, given that he's seen by them as a combustible character. So this is the situation, and this is what I believe triggered his anger. He's clearly frustrated, and things are not moving in the right direction for him. Initially, he said he was going to defend himself, only for him. I mean, initially, he served his lawyers and said he would do the defense by himself, only to chicken out of that and said, no, I'm not even going to defend myself. So my suspicion is that since he did not enter any defense, he believes that the judgment will be set aside if and when the judge decides to sentence him. It will be set aside because he did not enter a defense. And the judge tried his best to get him to rethink that decision to not enter defense. So Kanu still insists. The moment he heard of the judgment date, he got angry and was saying all kinds of things. Like he said, useless, mad people, you don't know what justice means. Your constitution says you cannot try anybody unless the law is written. Useless people, you don't know law. Your own constitution, you don't respect. Supreme Court judgment, you don't respect. Why are we in court of law? Why are we in a court of law? You think Britain can ask you to jail me and you will jail me? So Kanu claims that the Nigerian courts lack authority to try him. This is what he's been saying for some time, and that the law under which he is charged does not exist. But the Terrorism Prevention Amendment Act of 2013, which was duly passed by the National Assembly, Section 30 of that Amendment Act says the Federal High Court located in any part of Nigeria, regardless of where the offense is committed, shall have jurisdiction to try offenses under this act. And then in Section 1, subsection 2 of the same law, terrorism is defined as any act deliberately done with malice, aforethought, which may seriously harm or damage a country or international organization and is intended to intimidate a population, compel a government to act or abstain from acting, or destabilize a fundamental political, constitutional, economic, and social structure of the country. That is how terrorism is defined in that law amended in 2013. In May 2022, the Terrorism Prevention and Prohibition Act replaced the previous versions of the terrorism law and merely consolidated them. So it's not as if the law does not exist. So the laws, the terrorism law had always been there. But Kanu wants us to believe that there's no law upon which it should be tried. But the Terrorism Prevention and Prohibition Act of 2022 only consolidated the laws that already existed. So it's not like our terrorism law had not been there, it had been there. Even in 2015, when he was arrested, we had an anti-terrorism law. We had a law against terrorism, and he's being charged with terrorism and treason. So all along, I think that it looks like somebody who has resigned to fate, because once his no case submission failed, it's once an accused person moves a motion of no case submission and it fails, it is extremely injurious to that accused person's case. Because once your no case submission is set aside or is overruled by the judge will proceed to tell you to go ahead and enter your defense. And you will have put a substantial portion of your defense in that no case submission to say, look, you cannot try me. You have no reason to try me and another. So if that is set aside, it is bad omen for any accused person. Are you listening to me? Okay. It is bad omen for any accused. It is bad omen for any accused person. So some of the issues that Nnamdi Kanu even brought up on the day he first said he was going to defend himself, those cases had been decided by the court when he filed a no case submission. Those cases had been decided against him. They've been resolved against him. And then the issue of his medical report that the enemy brought forward. Kanu insists that that report was fake. But that was not canvassed. On the day that the report was brought to court by his lawyers. So the court already took a decision on that by admitting that report in evidence. So once it's admitted in evidence, how does the court now go back to undo what it had done and then say, oh, the report is fake? And it points to the fact that the Court of Appeal actually set him free. It's true that the Court of Appeal set him free, but what is also true is that the Supreme Court quashed that judgment of the Court of Appeal, which was in favor of Nnamdi Kanu. So to continue to argue that you should be set free based on the fact that the Court of Appeal ordered your release makes no sense, especially given the fact that the Supreme Court had decided to void that same judgment. So this is where we are. Ideally, I would have allowed him to defend himself,
That's
get
right.
the lawyers, good lawyers to defend him. It can make a difference. Even if he gets sentenced, a good showing by his lawyers could cause his sentencing to be light, could lead to light sentencing, you know.
That's right.
But he has decided to forego all of that, forego his right to be defended.
The defendant. Sure. Yeah.
And I just wait. So, um, judgment is set for November 20. And where you fail to defend yourself, the case of the prosecution will be used to decide your matter. The arguments put forward by the prosecution will be used to decide your matter. This is where
That's
we
right.
are on Nnamdi Kanu's matter.
That's right. Chidi Okonkwo says, man, Kanu has got a point. Calling that judge useless might be harsh, but after years in detention without a fair shake, who would blame him? The judiciary has been dragging this since its 2021 a tradition. Aisha Ibrahim says, totally disagree. Kanu refused to defend himself, so the court had no choice but to set judgment day. Blasting the system just shows he's desperate. We've seen this with other separatists. History repeats from Biafra days. Emeka also says, this outburst exposes how politicized our courts are. Remember the NSAS trials, same vibe, ordinary folks get screwed while big shots walk. Fatima Bello says, challenges ahead for sure. If judgment goes against him on November 20th, it will spark more unrest in the Southeast. Ngozi Eze says, historically, this echoes the unfair trials of the 1980s. Kanu's rant is a cry for equal rights. But vis-a-vis, but challenge is how do we balance security without alienating communities? It says, tough one. Abanji Okesoto says, Kanu failed to show any sense of remorse, and that has made political resolution of his trial quite difficult. Eko Akete one says, the trial judge is very fair to him. Well, I know we've been talking about political solutions, and I know that you have also advocated the same cause on behalf of Nnamdi Kanu and the entire uh, people, the agitators, generally for peace to reign. But if the judge, what's it called, hits the gavel on November 20th, do you think there will still be a window or an opportunity, or would this definitely foreclose the opportunity to have a political solution to this quagmire of Nnamdi Kanu?
No, I don't think so, because this is not the final court. After this judgment, there will be the Kanu will appeal. I expect him to appeal. And then after the appeal, the matter will go to the final court, which is the Supreme Court. So if there's genuine desire for rapprochement, a genuine desire to settle the matter out of court, and conditions are set, and both parties agree, then anything can happen. I don't foreclose a political solution at this stage, because it's just the court first instance, as they are called. So still the matter will still be appealed.